Now, let's talk about the Woyomegate money. It's Ghana money, 51 million Ghana cedis. He was ordered by the Supreme Court to pay how many years ago? And still, we are chasing after that money. And Occupy Ghana, the NPP have all issued statements suggesting that there is some obvious collusion to shield him. Attorney General Martin Amidu, former Attorney General Martin Amidu, whose solo effort led to the Supreme Court pronouncement on that money for it to be recovered, says, among other things, that what is happening now is because the president has ordered the Attorney General not to collect the money. I'll start with you, Yao, on this. You follow the processes, right?
Yes.
Okay.
I am not only deeply worried about the withdrawal in the Supreme Court, but also about the substantial allegations made by Honorable Martin Amidu.
It's not withdrawal, discontinuance with liberty to come back.
Yeah. Discontinuance
Whatever that
with
means,
liberty
yeah,
to
go
come
ahead,
back.
yeah.
At this point implies that they are not prepared to move ahead, particularly since the application had been granted. And the next step was to go in and do the interrogation. And then you discontinue with liberty to come back. In a very short while, you may not even have that liberty. But anyway, the Supreme Court decides, recover the money. First of all, it was at the instance of an individual, Martin Amidu, not at the instance of the state. And then, having had the hard work done by an individual, the state is unable to recover the money many years down the line. You adopt a process that will give you the opportunity to interrogate what happens, and then you discontinue. Now, Martin Amidu has stated two big things. Martin Amidu, and from my information, which I've picked from the internet, I could be wrong or right, yes, from his own site about the position he's made into court, he's stating that, essentially, the essence of what he's stating is that Woyomegate is blackmailing the president and the Attorney General. And that Woyomegate threatens to spill the beans about who shared that money, and that would bring the government crashing down, and that is why they have withdrawn. It's a major allegation. Well, let's not forget that Woyomegate has stated before that the Attorney General was one of the lawyers on there, and that she received $1 million, is it $1 million or cedis out of that process, or was it €1 million? The Attorney General has been cited before when she was in private practice for receiving monies from that suit.
No, you mean now, receiving monies on behalf of her client.
Okay.
That's more precise. That is what was put out there.
On behalf of her client. So
yes.
These were monies that were supposed to go to Woyomegate.
Playing with Woyomegate. No.
Who had the litigation against Woyomegate?
What's the Austro Invest?
Yes.
She took the money on behalf of Austro Invest.
Yeah,
who sued Woyomegate?
Yeah,
very well. But here we are. Martin Amidu's allegation that the president is being blackmailed by Woyomegate, and that the Attorney General herself, who is supposed to be the one putting pressure on Woyomegate in the court, is impacted by that blackmail, and so the president has instructed that she step back, even if with leave to go back into court, but she steps back. It's a major one.
What's your understanding that the Attorney General went to court with this process without any
reasons,
any consultations with the president?
No, I'm saying that Martin Amidu says the president instructed her. That is beyond consultation. That's orders. So she may have gone to tell the president that Martin Woyomegate is on the verge of saying things that he shouldn't say in the event I go ahead to question him in the Supreme Court, because he'll be speaking on oath. He will have to tell the truth.
And I'm asking you, sincerely suspect that these are issues that they would not have taken into consideration before going in the manner they sought to go?
All along, the state has been compelled to do something about the Woyomegate matter. They have been very reluctant. They have been compelled by public opinion. They have been compelled. First of all, they were not the ones who blew up the matter. When the matter was blown up, they denied it. And then later they said, oh, they'd been defrauded. They'd been arm robbed by Woyomegate. And then when they went to court, they messed up the criminal case. If you remember, they messed up the criminal case. And now an individual went in there to ask the court to specifically order that Woyomegate return the money. So the court goes in and tries to forfeit his property. going into execution of the judgment. He refuses. So
all of that was done by the Attorney General, you know.
Yes, after citizen vigilante had secured a judgment for them. So they were executing a judgment procured by an individual. That's what I'm saying. Now, in that one, even that one, it took them how many years? The judgment was procured in 2014?
Yeah.
Or 2014. We are in 2016. They are not able to recover the money. Then you go by application, the Supreme Court grants you the opportunity to do exactly what you are trying to do over 2 years. And then you come in and say, I don't want the opportunity anymore. And you don't have to give reasons, so you don't give reasons. And I am saying that it is sufficient to infer, and it's backed by the person who is in a position to know. Martin Amidi is peculiarly in a position to know what is going on inside the corridors of power. He just emerged from that river. And as we say in our local parlance, when the crocodile comes from deep within the river to tell you that there's a dead wood in the river, you have to believe him. Well, you can't go down there and find out. Martin Amidu is a crocodile in this pond. And he comes out and says that he is sure, he is certain that the president is being blackmailed, the AG is being blackmailed, and that is why they don't want to interrogate Woyomegate, and that he is prepared to interrogate him for him to spill the beans. Then he goes on to say something very, very remarkable. He says, gargantuan crimes have been committed. Gargantuan crimes have been committed. This is what he says in addition to the allegation of blackmail. This is the same man who said that a committee had been set up in the castle to investigate the purchase of aircraft from Brazil, and that there was arm twisting, and that the committee was dissolved through that arm twisting, and indirectly he lost his job because of that committee, as well as his insistence on prosecuting Woyomegate. He lost his job as an anti-corruption crusader in the government.
You have heard Abraham Amaliba, who is associated with the government and the party's legal team. You have heard him say that the discontinuance is not for the reasons that Martin Amidu adduces or Occupy Ghana speculates, but that Woyomegate wrote to the Attorney General upon learning that this was what was going to happen, wrote to the Attorney General to say that he's willing to pay and was asking for a meeting. We understand that meeting is supposed to be held coming Monday, which would, as it were, facilitate the process to get the money paid in a rather smooth manner. Why don't you want to believe that?
Because Amaliba is not the authority on this matter. Amaliba steps in to speak for the Attorney General on the discontinuance and gives reasons. The Attorney General doesn't have to give reasons. If the reasons were so soft and innocuous and happy ending for all of us, she could have given the reasons herself. A staff of her department could have given the reasons. So if she chose to exercise her option of not giving reasons, I don't think it would be valid enough for Amaliba.
When was the last time you heard the Attorney General publicly speak to issues like this?
She could have had a staff of the office speak to it.
Or the staff, the Attorney General's department?
Then I don't think we can benefit from Amaliba because we don't know Amaliba as being authorized by anybody in this matter to speak to it. Has Amaliba cited the letter, and in what capacity? Is the AG working with Amaliba?
What Amaliba has said has not been controverted.
Yeah, but that's the point I'm making. You say they don't speak. So maybe even if you are saying something that they will not controvert it. They are yet to controvert Amidu. And yet they have to meet Amidu with written submissions. They will have to go in there with written submissions denying these things. So if they go in there and put it in the written submissions that, oh, it was because they received a letter that monies were going to be paid by Monday. I think the reason is innocuous enough for the Attorney General to have told the Supreme Court, a very distinguished panel, that the person I seek to interrogate before you has come to his senses and has opted to speak to me directly. She could have told the court that for the court to feel comfortable, because this is a matter, a running sore as far as the court is concerned. The court has had very harsh words in this Woyomegate matter. Don't forget that the court pronounced that it was create, loot, and share, even though it's obiter. That you are there creating, looting, and sharing in these same Woyomegate matters. So for the court to grant you such an application at the highest level and for you to withdraw, to discontinue, without telling them why, even though you're not compelled to. And then step out of court for somebody, yes, part of the party legal team.
Okay.
Not the government legal
Felix,
team.
what some critics are asking is, why don't you let Woyomegate appear in the court on 10th November as had been scheduled to tell the court what he's telling we are told he's telling the Attorney General about what he wants to do. After all, he promised long ago that he was going to pay within a certain year, and not a dime came out. When steps were being taken to forcibly get the money, he has done everything to frustrate all of those steps. Now, he seems to claim that he doesn't own a single property. All the properties have metamorphosed into the names of other persons. How can you trust such a person?
Well, first of all, let me state that for the avoidance of doubts, Mr. Martin Amidu's claim that the president instructed the Attorney General to discontinue this case because of blackmail is gratuitous falsehood. He has only recycled long-standing MPP propaganda and presented them as fact, the basis upon which he proceeds to launch this attack on government. Mr. Amidu left government 4 years ago, and therefore cannot be said to be somebody who works within the corridors of power. Even within the NDC, that he remains a member, he's on the periphery. I therefore find it most strange that he would even put his name to this allegation, especially when he does not provide a shred of evidence to back such serious allegations. And I think that it is not in his interest to continue to peddle such falsehoods.
What sort of evidence are you seeking?
No, but first of all, how do you tell the public that the president has been blackmailed without
sworn deposition?
No.
This is a
No,
sworn
no,
deposition
please,
filed
please,
before the Supreme Court.
please. I am saying that Mr. Amidu, in his public statement, did not speak about who even told him what he's saying and why the public should believe him. How do you just get up, stand on radio, or issue a statement and say that the president has been blackmailed and expect that it to be taken simply because it is Mr. Martin Amidu?
In his public statement, he's making references to matters he has already put before the Supreme Court. And the matters he has put before the Supreme Court, he has sworn to them on oath.
But I'm saying that, so the Supreme Court is simply going to say because Mr. Martin Amidu has sworn on oath, what he is saying is true, even though he does not bring evidence. Is that what the Supreme Court is going to say? Or is that a position that the court is going to adopt?
When you swear an oath to something, it is a serious matter.
No, but I'm saying that for us members of the public, those watching us now, if Mr. Martin Amidu says that the president of this republic has instructed the Attorney General to discontinue a case because he's being blackmailed, we have to go beyond the sworn deposition and ask him to provide us with appropriate evidence before we can believe him. I am telling you as a matter of fact, as a member of this government, that no such instructions have emanated from the president of this republic to the Attorney General. I do know that the length of this matter has the potential to create a certain misimpression that government is not interested in retrieving the monies. Now, nothing could be further from the truth. In fact, when Mr. Amidu himself started proceedings to retrieve this money, when he was Attorney General, in his own words, he said it was the President of the Republic of Ghana, then President Mills, who instructed him to go to court to take further action against Mr. Woyomegate. That was before he left government. He went to court subsequently in a private capacity on the basis that the Waterville contract, from where all this Kabudu stems, was unconstitutional because the MPP government at the time that entered into that contract did not respect Article 1815 of the Constitution. So the Supreme Court ruling was based on the fact that Woyomegate benefited from a claim emanating from an unlawful contract. Sometimes in the public discourse, people overlook this particular fact. The reason why Mr. Martin Amidu succeeded in court was that provision in our Constitution.
But so you also know that there is evidence also on the record of the court that he was not in the first place deserving of that payment.
Yes, but
that every payment that was due had already been made.
But the point is that government admitted long ago that that payment was done in error. It is something that government has said publicly. But we need to place it on record that when Mr. Martin Amidu went to court, he went on 1815. And so the party that was in power and was responsible for that violation cannot turn around.
What violation?
Oh, please. For violating the Constitution. You have violated 1815. Is that not what Martin Amidu took to court? So please, we need to get that fact straight. The other point is that it is also not true that government has taken no action to retrieve this money. You spoke about his properties that have been attached. People have come forward claiming that those properties belong to them. Now, you cannot overlook such a claim because whilst it is important to go after somebody who has received money unlawfully and retrieve same, you cannot, in the process of doing that, go and sell property that you believe to belong to him only to find out that it belongs to somebody else. It gives you more problems. I understand there is something you call interpleader, where somebody who is affected that way can come up and make such claims. It is only fair that they are given the opportunity to establish their case before we proceed further. The other point is that some money belonging to Mr. Woyomegate is garnished by the state. It amounts to $100,000. It is woefully inadequate in the larger scheme of things. But that is the money that we've laid hands on. The third point is that indeed Mr. Woyomegate's lawyers have written to the Attorney General indicating that their client is prepared to make good payment on this particular matter. And in a case like this, it is appropriate that you listen to that. And let me put it beyond doubt that indeed the Attorney General was written to. I have the letter here, a scanned copy of it on my phone. It is dated 27th October 2016.
Can I see?
Yeah, you can see it. It has a stamp, the law firms, everything. Yeah.
Okay.
The next page shows the signature of the...
Right, it's from the law firm that is known to belong to be Mr. Woyomegate's lawyers.
Representatives.
And this is dated the 27th of October 2016, and it's addressed to the Attorney General, and it's titled Civil Motion as in respect of the case. And shall I share?
Sure,
of course.
Go ahead.
It says, reference is made in our capacity as lawyers for Alfred Agbesi Woyomegate to a recent order of court under the hand of His Lordship Justice Eni Yeboah in consequence of an affidavit of Mrs. Dorothy Efriye Ansa and Mrs. Stella Badu, Chief State Attorneys, in support of a motion ex parte in the above title suits. Then they quote the suit.
Yeah.
In the said order, reference to immediately above, our client is to appear before the Supreme Court of the Republic of Ghana to be examined orally on oath by your good self on whether or not, on whether our client has any property or any means of satisfying the judgment. Permit us, if you may, to excite your recollection on two previous concrete attempts made to you by our client praying for an opportunity to pay the said judgment debt in installment. Alfred Agbesi Woyomegate's personal letters to your good self dated 12 February 2016, and then a motion and so on accordingly, and pursuant to the instructions of our client, we hereby humbly submit that our client has a clear intention to pay the judgment debt and bears...
the next page shows you the conclusion, the signature. Let me open it for you.
Okay.
Yeah, but
okay.
I mean this, yeah.
And bears Alfred Agbesi Woyomegate as a law-abiding citizen of Ghana, has and is always willing to pay the adjudged sum of money by installment, giving the opportunity contrary to any perception otherwise. We humbly submit. Yours faithfully, signed by Kenanko at law. Thank you.
Exactly. So it puts it beyond doubt that indeed such a representation has been made.
Okay, thank you. Thank you very much. Just hold on briefly for me. And good to have you on the line, Mr. Martin Amido. Welcome to Newsfile.
I knew it. I knew you'll come on. Yeah. Mr. Martin, I predicted that you'll come on.
Hello, sir. Good morning.
Nice to respond to that.
Good morning.
Great. It's good to have you on the line. Your integrity is being put on the line as regards your source of the information and the truth of it about the claim that the government is under pressure not to, examine Mr. Woyomegate as it intended to do earlier.
Oh, there's a problem.
The line is bad.
Hello?
Yes, I can hear you. If you heard me, go ahead and respond. I get the impression that you're...
I am not going to respond. I'm saying that I'm not going to respond to frivolous allegations about my integrity being on the line.
Okay.
Who has made such an allegation?
Right, but
it's not true.
but
I am going to correct misrepresentation being made to the public.
Go ahead.
Okay, go ahead, please.
Which is that it was the NDC government, through its Attorney General, who paid the money to Woyomegate. It was not the MPP government which paid the money.
But nobody has said so.
Please, can you reduce the volume on the set before you? Reduce the volume on the set before you. Either TV or radio, just kill the volume. Yes.
You know what I'm saying is the 51 million Ghana cedis debt was created by the NDC government and paid to Woyomegate. The MPP government didn't pay that money to Woyomegate.
Okay.
So it is wrong for anybody to say that it was the MPP government who created that debt. And the Supreme Court says that it was unconstitutional for the NDC government to pay the money to him. And all I'm saying is that that is the position. Don't put it on some other government. And the NDC government, through the Attorney General, was the first defendant. And the Supreme Court found that their conduct was unconstitutional. So the NDC government, through the Attorney General, is itself guilty of paying the money. And that is why they should retrieve the money. And they are not trying to do that because they are interested parties. The facts are in my affidavit. The full affidavit is posted on my website. I have sworn to it. I am going to meet them in court on the 10th. I will at least, whatever, if they want oral evidence, it will be adduced. So I don't want the government representative to question my integrity on phone. And he should not represent the fact. Yes, the contract was done in April 2006 during the MPP. But the MPP didn't pay any money to Woyomegate. Woyomegate couldn't get them to pay, so he waited. When they were out of power, he said he was an NDC financier.
That's right.
He wasn't colluded with the government, and the government looted our money, 51 million, and gave to him. Collect the money, you are not doing it. And in any case, if there's a letter which says that they are going to come and settle with the Attorney General, why don't you go to court and ask for the case to be adjourned instead of discontinuing? Simple, common sense. You see, they are trying to steal and to defraud Ghana. They don't know how to do it. If the letter is true and it is based upon it, the Attorney General is wanting to discontinue, why couldn't you go to court on the 10th and ask for an adjournment to see whether Woyomegate's lawyer will settle with her? But it's as simple as that. Don't deceive the public. If you don't know what you are doing as a minister, please don't go to Joy FM and then steal life. That's all I want to say. Thank you very much.
Okay.
Well, Samson, I was on the floor.
Thank you, Martin Amidu. You heard him on the line, former Attorney General, and well, I think that in the end, by the time he finished, he actually got to the point that you made, that the contract was in the NPP era, but it's the payment, and I think that's
first of all, well, I would ignore the personal attack contract. It's obvious that either he's not listening or he's too emotional to listen to the points I'm making. The fact I made, and he himself confirmed it, is that when he went to the Supreme Court, he said the payment was unlawful because it stemmed from a contract that was unlawful because Article 1815 of the 1992 Constitution was not adhered to. Which government?
But additionally, I agree your attention.
Yes, I accept all of that.
There was no contract.
Please. The money was paid by an NDC government. That I told you.
And you said
and we have considered that it was in error. It is a matter that everybody knows. The third point is that nobody has come here to question his integrity. Listen, I have said that his claim, why he attacks the integrity of the president of this republic. And I'm saying that that claim is a manifest falsehood. I am challenging him to prove to the public here that the president of this republic any day instructed the Attorney General to discontinue this case.
Okay, again,
Because of blackmail.
Again, I have
That is the point I've said.
I have noted to you, and you need to pay attention to that.
I am paying attention.
That he has document processes before the court, and he has sworn on oath
Yes.
to them. In the processes, in the scheme of things in the court, when you have sworn to the depositions he has made, it's not taken lightly.
Yes.
So
but it is not the same.
until you have any proof you want to give,
No, you see something.
his statements will be taken
Samson.
as they stand before the court.
Samson. He issued a public statement in which he made these claims. Did he not? When he issued a public statement accusing the president of any country that he instructed his attorney general not to pursue this matter because Woyomegate was blackmailing him, he must follow that with concrete, irrefutable evidence.
I ask you, what sort of proof or evidence are you looking for?
But when he put the matter in the public domain, how does he expect the public to believe him beyond showing us?
You're not telling me this. This is the second time I'm asking you.
Samson,
what sort of proof are you looking for?
When you say that I have been blackmailed, what sort of proof must you give me to show that I've been blackmailed? Going to court to say that somebody has told me, and I swear that somebody has told me that the president.
Well, he says you will not be responding on radio.
No, but what?
You meet him in court. You meet him in court.
Let me make the final point.
No contract.
Let me make the final point. He chose the medium of the media to make that allegation. It is incumbent on him when he is challenged on the same platform to provide the evidence or forever hold his peace.
Thank you. Yes, Kufu,
Yes. You see, this is not the first time I've heard my brother Felix try to, rationalize the Woyomegate thing. Look, the Woyomegate payment, as the Supreme Court put it, was a product of create, loot, and share enterprise.
Be careful. Be careful. He has already sued you, and you are in court.
It was arbiter data. The view of one judge that we disagree with.
Please.
That must
Please, can we end it here? When you are being referred to it, he said what you just said.
But Kufu is raising it as though it's a fundamental.
Well, it's a finding by the court.
Go
ahead.
But we disagree with that view.
Reflected with the proceedings. All what the main judgment said was just a reflection of it. But the key point is this. The same court, the proceedings, the record of proceedings showed that Woyomegate had no contract with the government of Ghana.
There's no contract. But that has been admitted. It's public knowledge. The government has said so.
Thank you. You two, you're not helping. You're not helping it. Please.
Sorry for the interruption.
Specific. Woyomegate specific. He had no contract with the government of Ghana. So was undeserving of any payment to him.
Right.
That is key.
That's why the payment, according to the court, was unlawful.
Yes.
But Felix repeats that it was in error.
Yes, so we are looking at Woyomegate. We're not looking at the entirety of the Waterville and other things. The Woyomegate intrusion is clear that he had no contract, and that for that matter, there was no basis for payment to him.
Yes, but Timod went to court and stated that they paid him in a mistaken belief.
So then what a little bit more due diligence on the part of government would have avoided this kind of payment.
Right.
It was the political thing that was brought onto being, the thing about who caused the liability and not who had been paid any monies. If you remember that concept,
the president,
that dubious concept, that is what factored into this payment to Woyomegate. We are here on this platform. Government functionaries came here in spite of the documentation that was put before them to insist that Woyomegate had a legitimate claim to pursue. You recall on this very show. Yes. So please, let's put it clear. And in any case, see the Waterville matter. And Martin was smart. As a good lawyer, he knew how to proceed to the Supreme Court, the highest court of the land, in order to get appropriate judgment. So the constitutionality issue he raised was damn right. But the truth of the matter is that records will show that as far back as August 2006, some 6 or so, Joe Gatti had written a letter to Waterville telling them that in view of their inability to raise the funds and in view of the fact that Parliament had not approved, that contract was dead and paid Waterville for what work they had done. All these documentations were available. If the new administration had looked through all these things, they would not even have set up a mediation committee for Waterville to deal with Ghana government.
Including Kwame Tete's letter that was also produced to the Supreme Court.
Explosive letter. Dynamite of a letter. It was, they saw it and they ignored it because they didn't like it. So you see, that's not just bringing the constitutionality element in order to drag in the MPP administration. I think that's a poor attempt at
No, but that is in the Supreme Court, really. Why should we overlook it?
But that's not the, no,
no. Let us be fair.
You have made a point over it.
I am saying that attempt is
It is not. It's a fact.
No, you see,
it is a statement of
fact that doesn't help your cause.
No, I haven't said that it has helped anybody's cause. I have said that it is a fact.
So now let's move. Let's move. But it's not the first time.
We'll have this
This thing that has happened, the AG, I'm disappointed though, let me be honest, but apparently it's not a fatal injury.
Yeah.
If I read the Occupy Ghana statement carefully, I get the impression that one, that the order that the Supreme Court gave stands in spite of the AG's notice of discontinuance. Am I right? It stands.
Which order would it be?
The order that Woyomegate should appear to be orally examined. If I get them, let me read this and see if it makes sense. Yes.
Read it.
First, there is no pending application for one to be discontinued. That application has been moved and granted already. What there is
From what
now,
I see on Clara's note, who is the last to speak? You are preempting her, but go ahead.
Oh, she might do a better job.
Yeah, go ahead.
Yes, I like her legal prowess, let me be honest. What there is now is a valid and subsisting order of the Supreme Court, which cannot be discontinued by any party. Until it is set aside or vacated by the Supreme Court itself, that order remains. We expect that on 10th November 2016, Woyomegate will still show up in court. If he refuses to show up, the Supreme Court could compel his attendance. Second, technically, Woyomegate is a witness of the court,
That's right.
having been summoned on the orders of the court. Thus, even if the Attorney General refuses to attend the 10th November 2016 proceedings to examine Woyomegate, the Supreme Court itself has the power to ask those relevant questions, and Woyomegate will be compelled to answer them and provide all the information required. Third, and thank God, and I love this one, Mr. Martin Amidu is still alive and well and is still a party to the court action. He has every right to appear in court on 10th November and seek the permission of the court to examine Woyomegate, whether the Attorney General shows up or not. And with Martin's intervention a few moments ago, I can see that there's...
Well, he's already followed up. He's already followed up here by filing a process in court to do this job.
I salute him. He's a great son of this land. And
Yes,
I salute
he must refrain from making unfounded allegations.
Now,
it's not fair to others.
Sorry.
Well, let me conclude.
These are processes before the court. He has told you something. You don't seem to get.
I get what you're saying, but
I'm
saying when you issue a statement accusing the president, you don't tell that you're going to file a process that somebody has told
well,
you.
I understand that the state is going to put him to strict proof.
Absolutely.
And he may even be put on the question of issues about perjury.
Absolutely.
From what you have said. So let's get to something and see how it pans out.
I didn't want to touch that, even
it's
though
so
I
unfair.
can see the principle.
Yeah.
The principle that when you make such allegations, you ought to eventually authenticate it. But as in this case, because you say he's put it in the court
in his
thing,
affidavit,
I think we don't have to worry ourselves
the state will
because
challenge
there will be an opportunity for him to.
But perhaps he should not have made public pronouncements.
Now, Clara, do you suspect that the state was afraid that, like Occupy Ghana says, well, they feel that they prematurely congratulated the Attorney General when they filed this process in court and were granted the opportunity to come on the 10th and cross-examine cross-examine Woyomegate. And they actually have simplified what will happen in the court, that he was supposed to be spoken to orally to find out, one, whether there are any debts owing to him. So if there are debts owing to him, you go for those monies. Two, whether he has any property for satisfying the judgment. Three, whether he has any other means of satisfying the judgment. Four, whether he used the monies paid to him by the Republic of Ghana in any investments within or outside Ghana. So they want to trace every aspect of where the money has gone to. Yes. Now, they suggest that, like Kuku just read, because the application has already been granted, there's nothing to go to court and discontinue. So
you set it aside, rather.
Yes. No, it's
you
been
can't
granted.
file a motion to set it aside.
It's been granted. Okay. You can't set aside what has been granted. No, you can go. yourself, you can't go to set aside what has been granted you. I don't see how that works. It's normally the opponents that will go and set it aside.
Thank you.
Now, Koku is saying, like read from Occupy Ghana's statement, there's nothing to go and withdraw from or discontinue. All they needed to do was to have appeared in court. Is it your suspicion that they were afraid that because Woyomegate will be a witness of the courts, if they went there and said, oh, the man has written a letter, the court will refuse them? That's why they took this step.
I don't want to speculate on the reasons for the steps that they have taken. But what I do know as a lawyer is that when you are going to court, you prepare your legal strategy. You think of all the, you imagine the worst case scenario, the best case scenario. You make your analysis before you adopt the particular strategy or procedure that you think most serves your client's needs. With respect to the Woyomegate judgment, there's finality on the issue. The Supreme Court of the land has declared, because litigation must have an end.
That's right.
It has declared that Woyomegate owes us 51 million. Yeah. And then
without interest.
Without interest. And it has to be paid. The Attorney General has to recover that money for the people of Ghana. The issue of the discontinuance, as we talked about, the order was granted. Once the order was granted, what are you discontinuing? And once the order was granted, I believe that the order would have been served on Woyomegate. What now means is that there is a court order that orders Woyomegate to do something, which is to appear in court to be examined. So I agree with that. I'm also of the opinion that I don't really see what the AG is discontinuing, because Woyomegate still has an obligation to appear in court on that set day. And then the court has I think the court, even when in other civil situations, when the witness is in the box, the court can ask questions. If the court wants clarity on anything, the court can always put questions to the witness. So I don't see why it ought to be defined in Woyomegate's case. And Martin Amidu has applied as we are told. Let's see what the court will say on that.
He says if the Attorney General, the state will not do that job, he wants to do it because he says so, he's also a party. So he will examine him as to his means.
Exactly. I think, yes, I think he has locus in the matter, because I think this whole thing started because of him. So yes, I think it's good the court gets, because he's filed the application already, right? And because the application is now pending before the Supreme Court, I don't want to go into what the Supreme Court is likely to do or likely not to do. I would wait for the Supreme Court to make its pronouncement. But from my legal opinion, I don't see, now Woyomegate is a witness of the court. I think the court has jurisdiction to deal with him as it pleases. I think it's, the Attorney General may choose not.
Irrespective of what they have filed, he should still show up in court. He has no...
There's a court order on him. I don't think the Attorney General doesn't have the capacity to vacate a court order that requires somebody to do something. So I don't think he would be excused by the...
But could she appear in court with a so-called
letter?
It's an interesting situation, Clara.
What would you have done? What would you have done? And you are into private practice and you do a lot of commercial matters. This is a purely commercial situation.
Yes.
What would you have done? Would you have taken his letter and said, I'll go and tell the court that I don't need you to come to the court anymore, we are trying to settle, or you'd have asked him to come to the court and tell the court what he wanted to do?
I would have asked him to come to, or I would have actually, like Martin Amidu said, if I was the one concerned, and we actually even agree, we'll come to court and say that we have reached some agreement, so we would want an adjournment for us to try to sort this out. And then failure of which we would come back to court. I wouldn't discontinue the matter. I would get an adjournment, and usually the court would grant such an adjournment. So we go, we see how we sort out the issue, and then if we have resolved the issue, then we can come back to court and tell the court that I have gotten all the information that we needed. So the matter has been settled.
Occupy Ghana says we shouldn't believe this because even to discontinue on the basis only of a potential meeting with him, you have not met, and you've not had any agreement.
Yes.
He says, Occupy Ghana says, this clear that something is just
and
not
there have
adding
been
up.
earlier unfulfilled pledges by the same gentleman.
So what happens if they meet, there's a letter, but the meeting, then they don't reach anything conclusive? Then you come and apply again? Exactly what is the AG going to do? Come and apply again for another order to be granted, or are you now going to revive this? Exactly what will happen if the meeting doesn't yield?
It's not tidy.
the intended
They
result.
disagree.
I'm not
Discontinuous with liberty to reapply.
Tell us about that. Sorry. Tell us about that. What does that mean?
This is not
I've
straightforward.
seen and I've heard a lot of emphasis put on that last bit of that process. It says they are discontinuing with liberty to reapply.
What it just means is that I can come back and reapply for the same relief.
Exactly.
But the question in this particular instance, usually that request is made before final judgment or a final order is made. If you are in court and you are discontinuing a matter with liberty to reapply, an application, for example, what it means is that the court has not pronounced on the application yet.
Right.
So yes, I'm stopping it, but I can come back. That's what it means. But in a situation where the court has already granted the order, what are you reapplying for?
There's nothing.
Exactly. What are you going to reapply for? The thing you wanted the court to do, the court has done.
Already done that.
When you start, you say, I want you to do this, but for some reason, I am stopping it. I'll come back later. That is discontinuing with liberty to reapply. So at a later date, you come back and say that, well, I'm back because whatever reason it no longer exists. So
supposing that it had not been granted, is this situation novel? Is it not standard practice that someone wants to talk to you and to come to an agreement to pay, and so you go and discontinue your case even before you meet and have a discussion? Is it standard practice?
It is standard practice when the order is not made. When
I'm saying that assuming the order has not been made.
But usually it's not
okay.
No, it's not. What is standard practice to adjourn? That one is standard practice. It is usually in practice you are probably discontinuing if you think there are some fatalities in your case that you want to stop so that you can go and cure and come back properly. But when it just has to do with the parties sorting out their differences, the usual practice is to adjourn.
When it's about payment,
Yes.
At what point do you ask for an adjournment? When it's about someone wanting to pay and stop the whole process going forward?
It depends. You could have it before you reach terms of settlement. You could have an adjournment so that you go and negotiate, because the court would allow you to personally negotiate how the payment is going to be made. So if you go and you have successful negotiations as to how the payment will be made, you will reduce that into writing, and then the terms of settlement, you come and file it in court and tell the court that, I mean, this is what we have agreed on, A, B, C, D, this is how it will be made. Exactly. And then if if one of the parties doesn't comply with the terms of settlement, you can come back to court to ask for an enforcement of that term, of the terms of settlement. Generally.
I see.
Something, I'm scratching my head. The Attorney General went to the Supreme Court and filed a process to discontinue with liberty
To
reapply. And the court granted the order.
No.
There's been no such.
They filed it.
They filed a notice.
What has been granted is the notice for the order
interrogation.
for the man to be brought to court.
Yeah. So the Attorney General's application
So
is
the
pending.
Attorney General's application is pending.
No,
The
it's not an
application has
application.
already been granted. The application to orally examine Woyome was granted, and a date was fixed,
Yes.
the 10th of November,
Yes.
for Woyome to appear.
Yes.
That's why Occupy Ghana and
But now the Attorney General
he's
has
also-
filed
she's also
a
saying-
process that she would rather discontinue.
Notice.
But that
Is that a
process,
notice?
Yes,
Right.
notice.
but that
Notice.
process hasn't been heard by the court yet.
I don't think it's an application for discontinuance.
It's a notice.
It's a notice. So it's more or less saying that, court, I hereby inform you that this is what I have done. It is not an application.
But you know that by practice, what they say, what Occupy Ghana says, what Clara is saying is correct in law. That there is nothing to discontinue because the application has already been granted. So what they have done is in error.
Would they show up?
If they don't show up,
They have to show up.
they have to show up.
The ones going
on the
to do
notice.
the interrogation.
So if they are not there,
So
what
if they are not
happens?
there, how can it happen?
No, but if
they're
they're
not there, what happens?
but that's why it's a witness of the court. So if they are not there, I think the court, like I said, even when they are there, the
Martin
court
even.
can still ask
And Martin
questions.
too.
The court will always ask
Martin has
questions.
also applied.
The court, you
So
leave
let's
out
hear
Martin for now.
Martin's
Let's leave out Martin for now.
Okay.
So
So let the processes-
hypothetically, the Attorney General doesn't show up because of that notice.
So let the processes go on.
Yeah.
What
But
is the impact?
I am
That is for the
completely
Supreme Court to now
against
tell us
this
on the
use of the
10th.
media to peddle allegations which are completely unfounded.
Okay, you're going back there, right?
Oh yes, it's an important point. Now, I'm surprised that you are not seeing the gravity of the claims that Mr. Hamidu is making, especially because of the paucity of evidence.
No, but you see, because of the fact that they will end up in court and that issue itself could be interrogated in court, I'm relaxed with it.
Yeah.
I am too, but perhaps
I just
no,
inform you
perhaps
that the state has indicated
absolutely
that they will put him to strict
but what does that mean?
of those claims.
It means that the state is confident
And
of
he
his
says
position.
he also wants to meet the
No,
state
but
in
you see,
court.
perhaps we
That's
should have
fair.
waited for
It's
the
fair. The court will
processes
deal with
to
it.
play out before coming to the media to issue statements to call the integrity of the president into question. That is my worry, and he does that a lot in.
No,
in
he
this
has the right to
case.
determine how he wants to
So do
speak.
we have the
His
right?
freedom of
So do
speech.
we have the right to point out falsehood in his claims? And yet, when you do it, he subjects you to attack.
Okay, we take a break here. We'll be right back. This is Newsfile. Well, you were leaving before I started. I was going to say that that's what you guys are asking for. So quickly,
Yes.
what's the point to be made?
Yes,
in a minute.
Okay, just the point to be made is to distinguish between the Attorney General's power to discontinue, for example, criminal matters, and then different from this particular case, for example.
Okay.
In criminal matters, before judgment is finally given, the Attorney General can just serve notice of what we call the nolli prosequi, that I am discontinuing
Or even
it.
a withdrawal.
A withdrawal. But with respect to this particular one, in which case, for example, like we said, the application to examine had already been granted. What actually the procedures would actually require is not for her to serve a notice of discontinuance, but to actually apply to the court to be granted the permission that, okay, you can discontinue it, for example. So I am not even confident that the notice of discontinuance in this case is competent to kill the matter. I think the proper
Well, there are
thing,
those who take a different view that
Okay.
it is okay, even though she could have gone to ask for an adjournment.
An
she
order
could
has
still-
been given.
She's not discontinuing the order. She's discontinuing the intended act of cross-examining Woyomegate.
so her cross-examination of Woyome,
Yes.
but that doesn't discharge Woyome of the order that the court
All right,
has
all right. Yes,
placed on him.
so it was you, Oli, that had that
Well,
point
that was
to
that
make.
point.
We,
yeah.
Okay, thank
we
you.
want our money back.
Okay, that's all.
And
That's all. We
government
want our
will
money
collect
back,
the
is
money.
it? And government will collect the money.
Absolutely, yes.
Right.
By NMP trying to run away from
No,
Well,
no, that's
okay.
not what has happened. Yeah.
Well, there's a good lawyer friend of mine who says that if you say you want evidence as to what Martin Amidu is saying, that it is the orders of the president that are at play now, there's nothing for you to find out. It's not far to find. The only way is to know is that the Attorney General is merely an advisor to the president or the government. The Attorney General, like any lawyer, goes to court on the instructions of their clients. And who is it? If the
No,
president
but you
says
must
don't
show
do this,
that
we'll
the
do.
client
And the
has
Attorney
given
General on her
specific
own,
instructions.
and the Attorney General on her own will not go and do that until the client has instructed.
No, but
so,
Samson, is
so,
it
so
your-
don't
your-
go to
your
court
lawyer-
seeking
is
to
it lawyer-
find
is it no, Samson, your lawyer
Is it going
friend-
to strictly on the issue of instructions, or you're also going to look at the
advice.
process. No, Samson.
but no,
You see,
that
your
scenario
lawyer friends,
doesn't play
you see, your
out
lawyer
in
friends'
this
argument is flawed.
particular case.
You must show that the client has in fact given that instruction.
Oh,
Is he?
all lawyers, when we go to
You see-
court,
you see something?
we say we are
Something,
acting on the
something,
instructions
something.
of our clients.
Oh no, but in this
But you
case,
see,
the
it is unfair.
client in this Woyome case is not
It's not
the
the
president.
president.
Okay.
It's the state. So
Right.
it is not accurate. I think it is not accurate to say that the client in this case is the
Because it's
president
vested in the
and the
president.
president.
Yes, but you
but
see-
still, if you look at our constitution, it is the Attorney General's sole prerogative to retrieve the money. What can happen is that the president can fire the Attorney General, but the president is not the person to instruct the Attorney General
process
on
or
what
procedure, yeah.
what to prosecute and what not to prosecute. But he has the power to
And
fire
also-
the
I see.
Attorney
Okay.
General.
And also,
That's interesting.
how are you going to show that he gave that instruction beyond providing proof?
Okay.
It doesn't matter.
Okay, thank you, thank you, thank
Martin
you.
has sworn to a deposition
Right.
before the Supreme
still
Court.
doesn't mean
that-
that.
that
Who-
could
the
be
court will-
perjury.
the court will
That could be
determine that
perjury.
we can-
That
yes.
could be perjury if he doesn't
Well, that is
effectively
his own
conclude
cup of
on
tea.
that
And
matter.
And
That's-
they've indicated that they are going to hold him to
Yeah.
that.
His leg must be on a stone.
Well,
That is
Nice
absolute-
work.
That's
Okay, thank you.
I appreciate
Thank
that
you.
that's a serious allegation.
Right.
It's captured in court documentation. Oh, that's true. The cure will be found there. But I just pray that the state doesn't make that their real focus. We want our money back.
Rather
That's
than
why.
pursuing him for
No, it is
president.
Maslamide who is making it an issue.
Okay,
Actually.
thank you, thank you, thank you. Now,
Yes.
how did it come to you, Kweku, that our parliament managed to find ways to approve a number of loans in the dying, moments of its life, approved quite a number of loans. I don't want to go through them here. We don't have time. And yet, when it came to the right to information law, they conveniently couldn't find quorum. And so that law has suffered yet another blow. So this is going to be the second parliament that's not been able to pass it.
Shame. It's a shame.
The processes have to be started all over again the next time.
It's we've been on it for how many years now?
For close to 13 years.
13? It should be more.
Okay.
Yes, it should be more. The right information bill has been there for a long time. Civil society advocacy, gone on and on and on. It's a shame, because I thought this time around we're going to make it. So I think Parliament hasn't done well. But I'm not too sure whether one can put it in the same context about the loans and in terms of the bill. I'm not sure it's right to put the two there. But this whole thing of, parking or padding loans and bringing them to Parliament at the last moment, it sometimes creates problems, because they are not even able to do critical due diligence in terms of the terms.
One of them complained that that's the situation.
Yes, it's true. It's such a load.
He said Makasibe Yeboah, the MPP's MP, he said he was going to Parliament House that morning, and they were going to work on a loan. He didn't have the documents. He would get to the house and they will give him the documents.
Yes, it's a real problem.
Yes. Once it's being handed to him, he was going into the meeting.
The fact that it's sent to the committee level and all that, it's still a problem. I think that it's a culture that we should be moving away from. I'm told in totality it was about 900 million or so. Am I right?
Right.
I haven't bothered to study which areas, projects that have been targeted. I'm not in principle against us going out there to acquire loans. It depends on what we're applying those loans for. But here, I think the emphasis is on the legislative thing, whether we give the legislature enough time to scrutinize these things and make sure that indeed it is in the larger interest of the country. That's a certain culture we should cut out of our body politic. It's been so for quite a long time, but the fact that it's been so for a long time doesn't mean we should continue justifying and rationalizing it. I'm disappointed.
Yes, Clara, what do you say about the situation as being complained about? Some of the MPs, particularly this MPP MP, Makasibe Yeboah, was complaining very bitterly about the situation. And we actually understand that for one of the loans in the course of this week, it was supposed to be a loan in excess of 100 and so euros or so. They were able to beat it down to more than half of what was required.
Something generally, when it comes to loan, my position generally has to do with two things. One is negotiation, how they are negotiated in the first place, and then due diligence on the terms. Is there enough time to do that? For some of the loan agreements that I have usually looked at, I am actually, if I get, like the opportunity I get now is usually to actually advocate negotiation, that at least we must have some skill to be able to negotiate terms that it shouldn't just be about the money. But a lot of the other terms as to even when to withdraw, the consequence of breach and all of those other things ought to be looked at. Whether or not Parliament, even when they get the opportunity to do the relevant due diligence, we would need a lot of time to talk about that. But because my issues with loan, it is difficult to put within, looking at the time, within the short timelines that we have.
And what do you say about the right to information law bill that has been on, and it's been a struggle for almost 13 years, as I say. Yes. The coalition on the right to information has issued a statement and is so unhappy about the situation, particularly because the president had committed himself to this. At the international level, he had given indication that this will happen. The Deputy Attorney General had also gone on an international platform and indicated that this was over and done with. The Speaker of Parliament, you remember after some of us wrote petitions to him, committed to having the thing done. And here we are, it hasn't happened.
which is a shame. As for I know the debate as to whether or not we actually even need the Right of Information Act to be passed. But leaving that debate aside, we have a bill in place already. We don't lose anything by having it passed. It's still, it's quite difficult to understand why, after 13 years or so, we still haven't got it passed. I think it should be, because the Ghanaian public does deserve, like I always keep saying, everybody is accountable to them. They do deserve to be able to know whatever information that is in the public domain. I would say what it has been said already. It's a big shame that it's taking us so long to pass this bill.
Felix, how would you answer this question? Because the level of commitment that was pronounced in the assurances and what has happened is terrible.
Well, they say Parliament is a master of its own rules. Government has done its bit.
Oh, government has been calling for things to be done.
The point is that government has done its bit with regards to the right information.
You have the majority.
The onus now is on Parliament to do what it has to do to get it passed. It is a matter of regret, really, that they were unable to do it before the rules. But with regards to the loans, I think that we also need to examine the importance of these loans, because the monies that were borrowed were not done with a view to wasting them. They are going to finance very important projects, like the Pokwasi ACP junction, like the second bridge across the Volta River, like the Eastern University, like the Tematu Akosombo rail line.
Phase 2 of the Tamale.
Phase 2 of the Tamale and Kumasi. And these are projects that will bring relief to our people and bring development to our country. I am all for due diligence and thorough scrutiny of loan agreements, but I don't think that it is fair to suggest that as a country we lack capacity to do negotiations. Negotiations are not done by politicians. So some people believe that ministers themselves are solely responsible for negotiations. There's a whole army of technocrats with various expertise. Sometimes external consultants are hired to help with these negotiations. And so they are well negotiated. If we have difficulties with the loans, we can point them out specifically. Also, I think that sometimes the media reportage and the twist that is put on some of the things that emanate from Parliament are problematic. The Eastern University, for instance, some of the reportage was woefully inadequate, and the majority leader had cause to complain about that what transpired in Parliament is not what was reported outside. An impression was created that a portion of that loan had been inflated, especially regarding the residence of the Vice-Chancellor, when in fact the problem was that it was the presentation of the estimates that created the confusion, and not that the individual components had been inflated. So it's important that in analyzing...
You're talking about the loan the minority is taking some credit for.
No, you see, again, it is misplaced credit. A certain figure was mentioned as what is going to cost to construct residence for the Vice-Chancellor. They included auxiliary work, roads, and other things that need to be done to level the topography for the building to be put up. But the building itself was not going to cost the amount that was quoted. Admittedly, in presenting it, those who presented it did not unpack it. So it made it appear as if the cost of the building alone was this much. But when further information was requested, it was brought and the issues were clarified. But it was reported as a victory for the minority. I don't think that is how it should be looked at. Yes.
Yeah, the Coalition for the Rights Information believes that this government has time to redeem itself, in the same way that if it wanted something urgently, would have called the members of Parliament back. Do you think that's possible before January 2017?
They are busy passing create, loot, and share loans. Why would they call back?
We have been at this for 8 years.
I have 2 minutes. I have 2 minutes. Please.
You attempt to bastardize our infrastructure. This is not something that.
These are create, loot, and share departure loans.
Tell that
you
to
bring,
the beneficiaries
you bring
of
a
these
loan
loans.
to Parliament of $900 and something million to buy a power plant, and when it is questioned, you reduce it by 300 million to 600 million.
Is that
what happened to the 300 million? You bring another loan to build a bungalow for 1.7 million euros, and when you are questioning, you say ancillary works and unpacking and all those things. The consultants didn't realize that it will impact the cost of the building, that a road to the building will cost so much. So in that contract, where is the component for building roads? Please. These are loans that are dubious and questionable, and that's why they are rushing them through Parliament. These are loans where people think that they can build and create and loot their retirement packages, so that once you
making claims that
create and loot their retirement packages,
after the implications of what you are saying to Parliament.
These are loans. No, Parliament It's just a sophisticated way of going through these issues because you go in there, you have your
The place that you want to go to.
You have your majority.
He's a parliamentary candidate.
Yes, we will have a majority. We will not misuse our majority.
Thank you.
We will not misuse our majority.
Thank you.
We have a
You have
majority
been
that passes
watching
dubious
and
votes.
listening to Newsfile here on Joy 99.7 FM and on your Joy News channel on Multi TV. My guests have been Abdul Malik Kwekuba, co-editor-in-chief of the New Crusading Guide newspaper. Clara Berry, she is a private legal practitioner. She teaches the law at GIMPA. And Yabuabenga Samwa is a lawyer and with the NPP. He is the NPP's parliamentary candidate for the Adenta constituency. Felix Kwachi Ofosu is Deputy Communications Minister. Thank you. I'm Samson Ladi Ayanini. The news is up next.
She's good.
Oh, yeah.